criminal defense attorney, Neil Rockheim.
This is Neil Rockheim. Welcome to another edition of Killer Cross-Examination. It's your podcast where we talk about all variety of criminal justice and legal issues. We talk about current cases, past cases, and we try to bring to your doorstep what I think are really some of America's last great storytellers. And there aren't a lot of great storytellers left. And in my view, those storytellers are America's best trial lawyers. I am pleased today to be joined by Mark Geragos. If you're a lawyer or you are or you've read Page Six or you've read any LA paper, magazine, if you follow virtually any rapper, celebrity, actress in the last 20, 30 years, you'll know that Mark Geragos is considered to be the go-to criminal defense lawyer. And I think he's actually become really the go-to litigator for many of these celebrities. He's also done some incredible things, which I hope he'll share with us if we have time in this episode. If not, we'll have to come back to ask him some more. But I know he's of Armenian descent, and he has fought passionately using his soapbox, his legal skills, and the power of his voice, and his knowledge to attempt to bring exposure to the I think Armenian massacres, Armenian genocide, and to even get reparations for Armenians who are descendants of those that were massacres, and or who were part of the massacre or suffered in the massacre. And if that's mostly correct, then I did it pretty good. Understand that I plan on talking to Mark at 3 o'clock Eastern time, but for a variety of reasons, it looks like it's sunny where he is. It's sunny here in Michigan. We thought, let's do it now. So this is going to be really ad lib, but if anybody can handle it, it's Mark. Mark, welcome to Killer Cross-Examination. It's really great to have you on this show.
Thanks, Neil, and I appreciate you talking about the Armenian genocide. You know, we've got the Armenian community in less than a month commemorates the anniversary about 105, 107 years ago of the Armenian genocide, and we're waiting patiently this year to see if Joe Biden, unlike Trump and unlike Obama, actually keeps his promise and calls it a genocide, or whether he kind of skirts the issue like both Obama and Trump did. So it's an important issue to the Armenian community.
Tell me, Mark,
it resonates.
You're clearly so you obviously take pride in your Armenian heritage. When did you, for those who don't know, what is the controversy regarding, if there is one, regarding recognition of an Armenian massacre or genocide?
Well, the genocide, this is what happened. Between 1915 and 1923, about 1.5 million Armenians, also Assyrians, Greeks, were wiped out in just an atrocious fashion by the Ottoman Turks. What happened subsequent to that is that Armenians in the diaspora were kind of scattered to the wind, whoever was left. My personal story that I often tell is when somebody tells me how they've got great problems, I say, you know, I had a grandmother and her name was Baritsa, and she was in a Turkish orphanage after her entire family had been wiped out. Somehow she escaped from the orphanage. She found an aunt of hers, and those two ladies made it to Ellis Island. And she was pregnant with my dad in Chicago by the time she was either 13 or 15. You never know how old she was because she was just told how old she was. And then her husband ended up dying during the Depression, and she raised my father and my aunt alone. And I say, if you want to talk about problems, that's problems. So the problem has been for the last 20 years is that the Turkish government refuses to acknowledge the genocide because they know that reparations will flow from there. And as I often say, Mount Ararat is occupied Armenia. There's been most recently this year a war that was fought over Artsakh, and the international community did little to step in. Turkey and and the Azeris were committing atrocities that were unbelievable. So one of the reasons I always say when people say, well, it doesn't have any relevance today, I said, it sure does. Look at Artsakh and the battle we just fought that got absolutely no recognition. And we ended up ceding a traditional Armenian land because the Turks and the Azeris knew that they could kind of escape under cover of night.
So I'm the grandson of Holocaust survivors, and it's a very delicate subject for me. Whenever anybody, it's one of those like real bright lines, and don't put your toe even within a foot of the bright line of questioning the legitimacy of the Holocaust. And that is that something that has happened and that resonates with you? Is that's what's going on? People question it?
Absolutely. Look, you have to read, if you're a student of history, Hitler in Mein Kampf, I want to say page 33 in the translated version, basically says in his blueprint for the Holocaust, after all, who remembers the Armenians? The Germans were there kind of as observers, and some would say architects for the Ottoman massacres and genocide of the Armenians. The word genocide was actually coined by Raphael Lemkin to describe what happened to the Armenians, which is, some of the Turks will tell you, well, how could it have been a genocide? The word wasn't even invented yet. Well, it was called, the definition of it in Armenian was medziergen, and clearly the word genocide was coined specifically because it was ethnic cleansing. That's what they wanted to do. They wanted to get, when they started similar, it's almost an identical blueprint as Hitler executed. They took the kind of the lawyers, the intellectuals, the thought leaders, if you will, and killed them all, and then started to go village by village. You mentioned the litigation that we were engaged in. One of the things we did was, based on the Holocaust legislation, there was, we used that as a blueprint in California to get a statute of limitations extension passed so that we could sue insurance companies for not paying policies that were issued during the Ottoman Empire. Now, the Holocaust people, because it was government to government, they didn't get, you couldn't go to court, or you could go to court, but you couldn't prevail. Because we never had government recognition, we could go to court. We survived some motions to dismiss. I remember getting discovery in some of the New York Life cases and looking at they had kind of cards, if you will, that would have the name of the insured, the wife, the kids' names in the village. And the anthropologist, sociologist in me was able to plot these cards and see that the premium payments stopped in each village at the same time. So you could just plot how they were wiping out village by village.
Unbelievable.
And by day, we went to the reinsurers, which we settled that case. Then we went to the reinsurer, which was a company called Father Cash Register, if you can believe that. They had been bought up by another.
Can't make that up.
Right.
You could make it up, but I wouldn't believe you. So I'm assuming
right.
that
They were bought by a successor corporation. And so when we did the due diligence in order to settle that case, we were looking at the same kinds of cards that were kept, the hard copy cards. This is obviously pre-computers. And I actually, one of my partners found a card, and it was Bogos Geragosian. And I asked I called my father, who was still alive then, many years ago. And I said, do we have a relative, Bogos Geragosian? And my father, in his usual curmudgeonly way, said, Mark, you're such a dumb shit, which kind of reverberated back to the time he was a prosecutor and used to call me. I thought my first name was dumb and my middle name was shit. He said Bogos Geragosian was his uncle. Bogos is Armenian for Paul. That's who he was named after. Bogos had given my grandfather his last savings to get my grandfather Ellis Island, his little brother, and then he got killed in the genocide. So, I mean, talk about getting chills as you're looking at
story.
something and seeing your career come full circle was amazing. The one
How
of
did
the
you,
interests.
Mark, how did that, I want to hear more about that, because that's an amazing story. I can really empathize, because there was at one point where I was trying to get a university in Vienna to posthumously recognize my grandfather, who had to I won't go through the whole story, but ended up in a camp, and then ended up in a camp, and then ended up getting out and making his way finally in the United States. But he was never allowed to get his medical doctor degree. And after he passed, I thought it would be quite a posthumous honor to attempt. And it gave me chills to always try to do that. I ran into a lot of closed doors and no return phone calls. How did you get into this litigation? I mean, obviously, in hindsight, it appears like a natural fit for you, but how did you get into it? And then how did you not let it just completely take over your life, given its personal connection to you and your family?
Well, for a while, there was he's departed now, is Marty Marudian, who was a pharmacist who was friends with my parents, and I actually dated his daughter in high school. And he had been trying for generations to collect on a policy. And his policy was, I believe, of his uncle. And he and Marty's would have been the heir to have gotten it. Marty was trying for years, writing insurance companies and getting nowhere. And then lo and behold, the California legislature agreed to pass a statute which allowed for a extended statute of limitations against insurance companies doing business in the state who had not paid their claims, which is a natural fit. There is a current congressman named John Garamendi who was the head of the Department of Insurance, and he was instrumental in championing the cause and getting it done. We had a initial success with two of the insurance companies, as I described, but then you'll love this, we ran into a German entity that just pulled out all the stops, got the Turks to come in and start writing unsolicited letters to the Ninth Circuit, and we reached roadblocks there, and they ended up invalidating the statute many years later. It was a deeply frustrating time, and given the Turkish atrocities since, it's amazing to me that they had any kind of influence whatsoever. But was
there a lot of litigation in this case? Were you in court a lot, or was it mostly paperwork and investigation?
No, we in fact, we were in court in the federal district court quite a bit, fighting what are called 12B6 motions. We also,
for those who are listening, 12B6 motion is a motion to have an early dismissal in the case based upon a court rule.
Yeah, and then we went up to the Ninth Circuit. I argued once in the Ninth Circuit, twice in the Ninth Circuit, and then in bank, because at one point we had a 2-to-1 decision. We flip-flopped the 2-to-1 decision, and then they asked for in bank, which means the entire Ninth Circuit, and that was a bloodbath. We got nowhere there. I think in retrospect, we just didn't have enough political swag at that point. The Armenians did not. The Turks had, and they continue to employ tens of millions of dollars in lobbying efforts, because to them, they consider this an existential threat.
Mark, how many, so that litigation that we're talking about is not something that a new, lawyer just hanging up a shingle could or should take on their own. Obviously, you got involved after years and years of success in various areas of the practice of law, and I want to ask you about that. Did you begin your career as a criminal defense lawyer, as a civil litigator, as a general practitioner? Did you cut your teeth in a prosecutor's office? Tell me where you started.
Criminal defense, and did almost nothing but for 15 years. I mean, when I first started was I think I did nothing but deuces, and which I often say is a great training ground because when you're doing a DUI, first of all, everybody comes in and usually has a dim view of your client. Second of all, you've got to deal with professional, I won't call them testifiers, I'll call them testi-liars in most cases, where you have cops who get up there and will just say anything goes, especially in those days, because you didn't have body cams or dash cams or anything like that, or cell phone cameras that could put the lie to anything they were saying. You then had criminalists who would get up there and basically give you their version of junk science, and judges who were increasingly hostile. You try 100 DUIs like I have, and it forces you to either sink or swim.
Tell me about your, when did you realize when you were in court as a lawyer that this was for you? Like, when was it? The day you put your name on the appearance? Was it your first witness? What was the day when you said, this is for me? Or are you still trying to figure out if this is for you? I mean, I know it's for you. Clearly this is for you. There's no question about it.
I had real doubts the first 5 or 6 trials because besides doing DUIs, I also took what are called court appointments. For those who don't know, it's indigent defense. And
you just dove right in. You dove right into litigating, and if the cases required trials, you just pulled your pants up by your britches and said, let's go.
My father, who was as I mentioned, a former homicide prosecutor, strongly believed in the sink or swim approach. So his
let fear be your guide, right?
Exactly.
He'll be fine. You can walk me in the pool. How do you know he's not going to fall in? Fear will guide him.
I remember when I got sworn in, which is back in 1983, and he took me to lunch at a then very nice restaurant in Los Angeles. We had the lunch, and then at about 1 o'clock, he says, "Okay, now go downtown." And I said, "For what?" I was going to go home and celebrate. He says, "No, you got a bail hearing this afternoon in federal court." And I said, "I don't even know that I'm sworn in federal court." He says, "I think you are," and set me down there. And I was arguing for a reduction of bail, and instead the judge doubled or tripled the bail. And I'll never forget her name, and I'll never forget that experience. But
that's funny.
Yeah, the addiction of trial work, as I'm sure you know, is when you get multiple acquittals. And when you get multiple acquittals, there's no better feeling, especially if it's a hard fought case, and you hear that jury say not guilty, not guilty, not guilty, not guilty. It's just something you can't get over.
So you have. So I wanted to talk to you because you're, in my opinion, you're a Hall of Fame lawyer. I do think, it's what I said in my opening, I do believe that there are few places left in the United States, maybe even the world, to find great humans, storytellers and people that can tell a story from beginning to end. And we trial lawyers tend to be some of the last great storytellers.
And trials are becoming extinct, as you know. I mean,
yes.
How many trial lawyers do you know that have tried a federal trial, jury trial, in the last 10 years? I mean, you can count on, 2 hands, maybe. I mean, it's just it's a rare and God forbid federal criminal jury trial. Other than federal public defenders, it's almost non-existent at this point.
Mark, so every lawyer has a style, and and one of my critiques of some of these trial lawyer schools are that they have a figurehead who is a successful lawyer, and there are several out there, and everybody wants to sort of copy that lawyer. And they say things like, be yourself, but don't be the self that gets mad. Don't be the self that laughs or tells jokes. Don't be the self that is self-deprecating. Don't be the self that can, so really not yourself. It's more like a sliver of yourself. So you're a storyteller, and you seem, I can tell you've got a very good sense of humor. So what's your style? How would you say, what is your style in court?
Let me tell you, I was blessed, and let me tell you why. and I'll tie some of that together. While I was waiting for my bar results, my father was trying a case with it was a 3-defendant case in federal court in Los Angeles. The 2 other lawyers were Leonard Weinstein, who if you've watched the trial of Chicago 7, is talked about in that trial, and there's a character played in that trial. And the other lawyer was Charles Gary, who was supposed to be in the trial of Chicago 7, and was in the hospital with appendicitis at the time. Now, Charles Gary also
he was supposed to be what's his name's lawyer, right? And they
correct.
Right.
And
right.
That's why Julius the Just kept gagging his client, who kept saying, "I want Charles Gary."
Right.
Charles Gary was like me, like Geragos. Charles Gary was an Armenian from California, who did the same thing. He bastardized his name the same way that my grandfather bastardized my name, which is, instead of Garabedian, it was Charles Gary. Mine, instead of Geragosian, it was Geragos. Charles Gary's style, Leonard Weinstein's style, and my dad's style, to watch the 3 of them in this trial was like nothing you'd ever see. Charles Gary, who had very little kind of formal education, but was what some people would call flamboyant. I just said he would capture the courtroom. My father had more of a Columbo style, if you will, and Leonard Weinstein was very clinical, very laser-like in his cross-examination. And you could watch how each of those things worked in their own way, which is, when you talk about killer cross-examination, I've always said, a lot of times people will say, well, you're known for destroying witnesses. And I said, no, what I really like the best is when I take what I call take a witness and turn them into mine and make them my witness.
Okay, so let's talk about that. So you are, I've read a bunch of different, excerpts from trials of yours. I know you wrote a book too about I think it's called Mistrial, which is sort of your expose on the challenges in the legal system, that the things where it works and times where it doesn't.
I like to always take credit that before people talked about the broken criminal justice system, I wrote a book about it 8 years ago.
I respect that. So to convert a witness to your witness, it is one of the great compliments when you get done and your client leans over and says, did we call that witness or did they? That is one of the great compliments, right, that you can get.
Right.
But is there a certain trick that you have? I mean, is there something that you look for in the witness when you're doing that? Do you have?
Yeah, one of the things that I think I tell my lawyers to do is listen to the witness. Make sure you're watching the witness and focus on that witness. Stop with the writing the notes and everything else. You got to listen to that witness, and you have to be observant. And if you're observant, and if you put yourself into their shoes, so to speak, which doesn't really emphasize enough what you have to do. You have to understand why they're there, why they're telling the story, whether they want to be there, whether or not there was something else working on them. And you just have to have empathy for the witness. You don't, just because the witness is up there trying to destroy your client doesn't mean that you still can't get them to tell the truth.
So I know that in court you've used humor at times to sort of, I don't know if it's, and I was going to ask you about this, to take a break, to reset the stage. Was it to hit a reset button? For example, one of the and you know the story I'm going to ask you about, in the Scott Peterson trial, you got up to question, I think her name was Amber Fry. And of course, everybody was probably steeled themselves at that point for what they anticipated was going to be a prolonged cross-examination. And you got up and you told a joke. I don't know if that was planned or if that was in the moment, but tell me about that and what was the purpose of it?
Well, we had kind of plotted out that was going to be the most challenging part of that trial. And mind you, I never expected to get a not guilty. What I was aiming for was a hung jury. I just think there's certain cases, as you know, that a not guilty in a frenzied atmosphere is just virtually impossible when you don't have a sequestered jury.
I have a dear friend that says that when they line up 100 witnesses against you, even if you slay them all, you've got to still climb over the 100 witnesses to get to a not guilty. It's still very, so that was a challenging case without
so
question.
I knew.
You do it, got it.
And yeah, I knew it. So
you were the personality. I mean, your client wasn't testifying. The public image for Scott was not, obviously, I don't know him, but I'll call him Scott, was not, that was, the byline or the subtitle on a news article was unflattering to him. And so really it was your personality that you had to sort of smear on him in a way.
Yeah, they're to a degree. And then those tapes were awful. The tapes with him and her. I mean, I tried to explain to the jury what it was, but I knew once they heard them that I was going to have a tough road ahead.
Tell me about
and so when I began
the cross.
I stood up and I said, "No questions, Your Honor." And the judge, DeLucchi, you've never seen his face. And then he realized I was joking, and it busted up the courtroom. But
what was was that deliberate on your part? What was
I mean, to some extent, to just try to relieve some of the, I guess, tension, if you will. It's the prosecutor, I think, did a masterful job of lulling the jury to sleep for the first 3 months of the trial until they put on Amber. And like I said, finally, the California Supreme Court unanimously reversed the penalty, and then shortly thereafter, issued an order to show cause on the issue that, or both are the issues that I was screaming bloody murder about, that the judge, when it was apparent after a week of deliberations that jury was hung, then removed the foreman of that jury because one of the other jurors was threatening them, and then put in as an alternate a woman who definitely was what I called a stealth juror. And that's what they're litigating now.
Did you have, there was science that was being introduced in that case, and then there was some pseudoscience that was being introduced?
Well, that was the first case in California that they introduced mitochondrial DNA. So we had to have an extended hearing about mitochondrial DNA. I thought we showed that it should not have been admitted, at least in the way they were using it. The judge let it in. They had dog scent evidence. We won about half of that pretrial battle. They had cell phone triangulation, cell tower evidence, which to this day, I've had that in several trials, I think is also tantamount to junk science. I mean, you probably have encountered this, but the idea that you can track the movements of somebody based on the cell phone triangulation is nonsense and should not be allowed in a courtroom. They had some other kind. I mean, it was just.
You destroyed. Tell me, you destroyed a couple of, I think it was Modesto police officers who had taken the stand and were trying to take a container and claim that it had been used to create some cement anchors.
Right.
And you turned out, if I know, tell me about that. And you were a little snarky when you were cross-examining on, you were smiling like you were now, but were you snarky? Were you a little sarcastic?
There were two instances where I got a little snarky. One was right after the judge, this is not even the foreman during deliberations. Halfway through the trial, he removed another juror, who was obviously pro-defense at that point in the trial. And I may have lost my cool in chambers when he did that over my objections. So he told me to go outside and cross-examine this cop. And I think I did say something snarky, and the judge realized this was not going to be a good day and recessed immediately. The other one was a officer, a detective, who clearly had excised from a report of an interview that Lacie had been at the warehouse, and that I caught him in that, and that was what people say was an aha moment, where you saw a cop or a detective who clearly had monkeyed around with evidence and reports, and the prosecution looked bad. They also did another thing, or I did another thing in the opening. They had gotten a judge to sign off on warrants by declaring in their affidavits that they had watched, Scott had given a statement, and they called him a liar and said that he had watched the TV show the morning before. Well, when we went through and watched the TV show, we subpoenaed the records and everything else. Sure enough, Scott had accurately described what he had seen. The cops had either been deliberately non-truthful, or were just completely negligent. And so we showed that in the opening statement as well, which was part of our theme, that they had a guy they wanted to convict. They weren't interested in actually solving the case. That was the theme of our defense in that case.
Now, I know we have limited time.
I was just going to tell you, I got a heart out in a couple of minutes, and
I know.
I'll bet you your wife wants you out the door too.
I want to know about the Whitewater, about the Susan McDougall, the back-to-back acquittals. It's rare for lawyers to get back-to-back acquittals with different clients in different courts months apart. This was like this would be like winning the Grand Slam in golf, right? I mean, getting
right. I will let me honor
set the stage for us with that.
Yeah, let me honor a friend of mine who at the time was kind of a mentor and a guy I looked up to, whose name is Howard Weitzman. And Howard had, when I first started practicing, had the DeLorean case. And Howard won what most people thought was the impossible case in the Central District of California, and DeLorean was acquitted. What people don't really remember, unless you're in the weeds like we are, is that he then went back, and may have been in your state, it might have been in Michigan. Howard tried a second case with DeLorean and won that back to back with the acquittals, which is, as you know, with a trial lawyer, that's very rare. And I saw that and I said, I want to be like Howard when I grow up. So the first one was in Santa Monica, and back then it was before Susqn was really known as a Whitewater figure. Back then the case was called the Maida trial, because the purported victim was, and complaining witness was, Nancy Maida and Zubin Maida, the orchestra conductor. And the Susqn was accused of embezzlement, 12 counts, 15 counts, something like that. And I thought when I first took the case, I went back to my father and I said, I really want to take this case, but she's got no money. And he says, look, if you think you can take it and do something with it, more power to you. And I looked at the reports and I said, this case should go away by, some kind of tax count or something like that. Thought I'd do a deal. The more I looked into it, the more I saw that this case was ridiculous. We ended up trying it. She was acquitted on 12 or 15 counts, whatever it was. Then her reward was to be indicted by Ken Starr in the Office of Independent Counsel. And the next thing I know, months later, we're in Arkansas and I'm trying the case there.
Which acquittal was more surprising?
The acquittal in Arkansas to me, because she just went in front of the grand jury and said, I don't trust these guys. I don't believe the Office of Independent Counsel is telling the truth. This isn't a truthful investigation. I'm not complying with the court order. So I will tell you that
strong words for Ken Starr after that.
Well, I think I have been vindicated. He says nice things about me in his book, but anybody who's watched Ken Starr during the Donald Trump impeachment has to say to themselves, dude, you really are not being totally consistent here. And I will tell you who was also down there off and on and in the Office of Independent Counsel back then was Brett Kavanaugh and Rod Rosenstein. And so all the alums of the Office of Independent Counsel are now either on the US Supreme Court or alums of the Department of Justice.
When you heard not guilty in Arkansas, were you surprised?
I was surprised that they hung on the 2 counts, because I thought they would argue, and the jury instructions were bad, that it was dead bang on the 2 counts. The obstruction of justice, I thought we'd win. And by the way, I think that may be the only obstruction of justice acquittal in a Office of Independent Counsel prosecution. So I love that, and I relish that to this day. Thank you for asking about it.
So I know we're coming to an end of our chat, and I would be remiss if I didn't revisit something that you and I talked about for a second before we started, which is, and I wanted to set the stage for this for you to give you kind of an open mic here for a minute. Trial work is so personal. And as you said, I don't know if you use a lot of notes or if you get up there and sort of have it committed to memory or a combination of both, but you look at the witness and it's important for your physical presence and your mannerisms and for you to see their mannerisms. How is that being impacted, in your opinion, by the teleconference and the Zoom technology, if you have an opinion about that?
I was adamant that I would not do any cross on any case by Zoom. And I actually have become very fond of Zoom for oral arguments or court appearances. I've done both everywhere from circuit courts to state courts by Zoom for oral argument, and I kind of like it. I've become a big fan of that. A week ago, maybe longer, no, about a week ago, I was sitting here where I am, and a judge ordered me to go to a courthouse that was farther away, ordered me in person in 2 hours. I couldn't get there physically. So I had one of the lawyers in my office go with the client to the courtroom, and I did the preliminary hearing by Zoom. And I did a cross-examination, about 5-hour preliminary hearing. The judge did not dismiss or reduce the case, which is what I wanted, but he was impacted enough to exonerate the bail meaning release the client on their own recognizance, and basically offered to not have her serve any jail time if we entered a plea. So we were effective, but I think if I had been there in person, I might have been able to convince or get him to have reduced the case, which is what I really ultimately wanted. So I'm not a fan of doing it by Zoom. I think you lose something, especially based on camera angles and everything else. I mean, when you're cross-examining somebody and it's the side of their head, it just doesn't do it for you.
They're looking off like this, and and you
Right.
wonder what, who's holding up the whiteboard behind you.
And if he's looking down, is he looking at notes? Is he or she looking at notes? That kind of stuff. Anyway, I appreciate it.
What lies ahead for you, Mark? What if someone wanted to, after this podcast, if they said, I want to learn more about what's going on with Mark Geragos, his cases, podcasts, books, what lies ahead?
Go and tune into my podcast, Reasonable Doubt podcast with
a good podcast,
Adam Carolla.
Very funny.
Right.
So
anytime you can do anything with Adam,
so tell me about it's Reasonable Doubt podcast, and you have a co-host, Adam
Carolla. Right. And that's the way to find out. It's weekly, drops every Saturday morning. So you got a new one today.
Any books coming out?
I'm putting something together. I'll come back and talk to you about it when I've got it in manuscript style form.
Any trials coming up?
Yeah, I've got a trial scheduled in August. Stay tuned. I had one scheduled in May. The judge just vacated it yesterday. So,
Mark, I know you got to run. You got a hard stop. Let me say it's an honor. To even appear on the same side screen with you, someone that I have looked up to. I still use your not a zip zero zilch when trying to make an impact. And I still think of you. I think I told you that. And I appreciate that one of the things I think you do for lawyers, you've got a smiling face, and it doesn't mean that you can't get mad and scowl, but I think that you have a sense of humor, and I think that you're good at seizing the moment. And I wish that more young lawyers would learn that you can use all facets of your personality. If you have a humorous personality, you don't take over the courtroom and do a stand-up. But if there's a moment to bring some levity, you're entitled to do that and to try to use your personality, at least to do it and learn how to do it. And I
couldn't agree more. More. I appreciate
it. I hope you guys are opening up in California, and I hope that I'll get a chance to see you soon and talk to you soon when your book comes out. So
thank you,
Mark. Thanks, man. Take care and be healthy. All right.
Okay. You too.
Thank you. Thank you, everyone.
Cross-examination, a podcast by your host, the nationally renowned criminal defense attorney, Neil Rockheim.